Okay, so hi everyone. I would like to welcome everyone on behalf of the Rocky Mountain State section of the Air and Waste Management Association. I am Lori Marcus with Bar Engineering, and I am a board member and a host of today's meeting. I would ask that everybody mute if you were not speaking. It looks like pretty much everybody is already muted. I have just one announcement today with regard to the Air and Waste Management Association. Unfortunately, we had to postpone our one-day technical conference due to COVID concerns. As most of you are probably aware, we had postponed the conference from this last May to October, but we ultimately made the decision to reschedule it yet again for October 7th, 2021. So please mark your calendars, and you should receive a formal announcement soon. Today's presentation topic is compliance program development for Title V facilities in the serious non-attainment area. Our presenters are Dawn Myers and Tony Widboom, both with Bar Engineering. Dawn is a senior air quality consultant with Bar Engineering. She has nearly 25 years of experience and expertise across gathering, transmission, and processing for the oil and gas industry. She worked for one of the largest energy companies in North America for over 20 years, where she was responsible for air quality permitting and compliance. She was appointed by the governor to serve on the Colorado Air Quality Control Commission for a 3-year term in 2009. She has a bachelor's degree in chemical engineering and a minor in environmental engineering from Colorado State University. And then we have Tony Widboom. He is a vice president and senior environmental engineer with Bar with 14 years of experience. His expertise lies in air quality permitting and compliance for a variety of industries, including petroleum refineries, manufacturing, mining, and power generation. Today, Tony has significant experience working on Title V permit applications across the country, including for facilities subject as a result of a change in attainment designation. He joined Bar with a bachelor's degree in chemical engineering from the University of Minnesota. So without further ado, I will turn it over to Dawn.
Great. Good afternoon, everyone. I just want to make sure that I am sharing my screen and everyone can see our compliance program development PowerPoint. Lori,
Yep.
can you confirm?
I can see it.
Fantastic. So as I said, welcome to compliance program development for Title V facilities in the Denver Metro Ozone Serious Non-Attainment area. I am Dawn Myers. And on behalf of Bar Engineering's Denver office, I want to thank you for your interest in this topic and for joining us for this presentation today. Our overall objective for today is to focus on complying with Title V permits. I will give you the background on Title V permitting, including the history, applicability, and discussion of the Denver Metro Ozone Non-Attainment area. Tony will then talk about the initial Title V application, modifications, and renewals. I will also show examples of the different reports, deviations, including an example, semi-annual monitoring reports, and annual compliance certifications. Tony will talk about compliance programs to track monitoring and record keeping in support of required reporting. We will finish up with about 10 minutes of Q&A at the end. We are now going to talk about history, background, applicability of Title V permitting, and the Colorado Ozone Attainment Area designation. The overall purpose of the Title V program is to improve compliance with air quality requirements by collecting those requirements into a single permit. The Title V permit harmonizes requirements from several different programs and reduces duplication. The Title V program does not change or modify those requirements. The operating permit program originated in Title V of the Clean Air Act. That's why they are sometimes also called Title V permits. The requirements for state operating permit programs are contained in 40 CFR Part 70 and also in Colorado Regulation Number 3, Part C. One of the goals of the operating permit program is to consolidate all applicable requirements into one document. It not only makes it easier to enforce, it adds clarity for the source. There are a lot of potential sources of conditions or applicable requirements, and it's going to vary for all of your emission units. There are new source performance standards, also known as NSPS, and National Emission Standards for Hazardous Air Pollutants, commonly referred to as NESHAP requirements. There are also requirements incorporated from construction permits or APINs. Perhaps it's initial stack testing or best available control technology requirements. There can also be state implementation plan, also known as SIP, requirements that are very specific to your source, as they might be laid out in an attainment plan for a maintenance or non-attainment area, like a facility emissions cap. Past enforcement actions, like consent orders, can also have requirements that are incorporated into Title V permits. All major sources are required to obtain a Title V permit. Additionally, certain NSPS and hazardous air pollutant standards, specifically require the source to obtain a Title V permit, though most do not. Sources subject to the acid rain program are also subject to Title V, but they are typically major sources anyway. There are rare exemptions, which we will not cover today, but you can find those in Reg 3, Part C. Major sources are those that emit greater than 100 tons per year of a regulated criteria pollutant in an attainment area. The major source threshold is 10 tons per year of any individual hazardous air pollutant, or 25 tons per year for all combined HAPs. Fugitives are only included for listed source categories, which includes many common types of facilities. There may be lower major source thresholds based on the severity of a non-attainment area for specific pollutants. Because of the redesignation of the Denver Metro North Front Range from moderate to serious for ozone, effective January 27, 2020, that major source threshold has dropped from 100 tons per year to 50 tons per year for nitrogen oxide and VOC sources. Any source in the ozone non-attainment area that became subject to Title V on this redesignation date has 12 months to submit a Title V application. So keep in mind the due date for these Title V applications is January 2021. Just a couple months left. We talked about major source emission thresholds, but what is a major source? Let's do the Cliff Notes version. Equipment meeting all three of these criteria are grouped together as a single major source. One, they share the same industrial grouping, evidenced by the first two-digit primary SIC code. Two, and you can tell that my background is oil and gas because of this bullet, the equipment on the continuous or adjacent properties at the same surface site or within a quarter mile sharing equipment for oil and gas activities under Major SIC Code 13. Unfortunately, other industries do not have such clear guidance on the distance requirement. And then lastly, the equipment needs to be under common control. A minor source of pollutants emits less than the major source thresholds. A true minor source has the potential to emit less than the major source thresholds without controls. A synthetic minor source has limited the potential to emit below major source thresholds, either with controls or with operating limitations. And the key here is that a synthetic minor source has to have a federally enforceable construction permit limiting those emissions. This map shows the area in Colorado that was redesignated from moderate to serious for the 2008 ozone standard. The Denver Metro North Front Range ozone non-attainment areas encompass the following counties: Adams, Arapahoe, Boulder, Broomfield, Denver, Douglas, Jefferson, and then parts of Larimer and Weld counties. There have been 3 8-hour ozone standards issued by the EPA in 1997, 2008, and 2015. Each of these standards became progressively more restrictive, from 80 parts per billion to 75, and finally down to 70 parts per billion in the 2015 standard. The 2008 standard of 75 parts per billion is the current threshold for determining attainment status. The redesignation from moderate to serious for ozone caused the major source permitting thresholds for facilities emitting VOC and NOx to drop from 100 tons per year to 50 tons per year in this non-attainment area. I am now going to turn the presentation over to Tony, and he is going to talk about the Title V application.
Hey, good afternoon, everybody. Can you hear me loud and clear, Don?
I can.
Okay, great. Yeah, this is Tony. I'm going to talk about the components of both the initial Title V application, and then we'll get into the modifications and renewals as well. So the CDPHE undergoes an administrative review of the Title V applications to determine, if it's received on time and if it's complete. Those are really the 2 main criteria they look at. The deadline for submitting the application, depends on the type of permit action, and we'll go through that in a little bit more detail. Don noted the major upcoming deadline being the 1 year from the attainment redesignation. Regulation 3, Section C3 lists what's required for an application to be complete, meaning it includes enough information to determine which requirements apply. And again, we'll go through each of those. So if your application is both timely and complete, you will receive an application shield. And what that means is it keeps you from getting any violations from having or failing to have an operating permit. So, just because you have to have a permit, as long as you've got your application in, you should be covered. It allows a source to keep operating, even if, like in the case of renewals, if the current permit expires until that new permit is issued or denied. So it's an important piece of legal protection. You don't want to be late or incomplete with your application. When you do an initial Title V application, you have to prepare, all the elements of a complete application because you're starting from scratch. When you're an existing facility, you are more or less, updating the information that's on hand for both the modifications and renewals. So, in addition to describing your facility, like these first couple bullets, the identifying information in your facility description, there are a couple pretty significant pieces that are more time consuming for the application. First being the PTE calculations, which is a site-wide requirement for all regulated pollutants, and they're used for confirming applicability as a major or minor, and I guess it would be a major NSR source, not minor for Title V, and a major HAP source, which you could be major for one and not the other and trigger Title V. The second, I guess, major requirement is the applicable requirements and the method of compliance demonstration, because that's going to really make up the bulk of what's in the permit itself. So when you have a permit in hand, it's not as big a deal to fulfill these application content requirements, but for the initial, it can be a lot of work. There are a few other explanation of proposed exemptions, compliance plan and schedule, any other data necessary to determine compliance with the applicable regulations, and your copy of your APENs on file with the division. Another key element of the Title V program is public participation, which does include EPA as well. And how it works is when you and the agency have finalized a draft permit, it's posted for public review and comment for 30 days. The public can comment on the draft permit and request a hearing if they're so inclined on that permit. And EPA has a concurrent period of review for 45 days in which they are also allowed to comment and object if they so choose. EPA objection is pretty significant event and would be a signal that they're not on the same page as the agency is. There is an associated process to resolve any disputes, 90 days to come to resolution. More commonly, if it really is a controversial facility, the public may be the ones petitioning EPA to object, and they have 60 days after the 45-day comment period from EPA concludes. And the key part of that objection is that the deficiency that they are objecting to had to have been raised during the comment period. So in these cases where it has to play out, the facility isn't in violation in the interim period while that petition is being resolved. So now let's move away from the initial application. We can talk about modifications and renewals for those sites that have Title V's. And there's varying levels of modifications, and we'll walk through those. There is a nice flow chart we wanted to bring to your attention on the agency's website. One type of modification we won't spend much time on since it's not undertaken by the source is reopening for cause by the agency, which isn't common but can come up if there are significant new regulatory requirements that have to be incorporated and it's more than 3 years before your permit expires, or if there's a mistake that the agency just needs to go in and correct. Administrative amendments are, one of the more common changes to Title V's. They are, pretty much what you would think an administrative amendment would be. It's typo corrections, changes of address, removal of equipment, and those types of activities. Minor mods, we put this in the middle because it's between administrative and significant, but it's really kind of the last thing you check, where you see if you're an administrative amendment, you see if you're a significant modification, and then if you are neither of those and you still need a modification, then you qualify as a minor mod. So it's things that the change wouldn't violate any requirements in the permit. It's not a significant change of permit requirements or require any sort of case-by-case determinations. For Title V sources, there are some there's some tie-in as well with the construction permitting program where you can apply for a Title V minor mod for certain construction activities and proceed with those. Minor mods do not go through EPA review or public notice, I guess, is one other key point. Neither do administrative amendments. Significant mods are, most commonly related to, adding new equipment, incorporating, significant new regulatory requirements or changes in operating limits that are enforceable in your permit. And these do have to go through EPA and public notice periods. And you might think of this as some larger projects like PSD review, or sometimes even smaller projects can trip you into a significant mod, like if you have an NSPS modification, for example, which is a Title V modification. So it's one more reason to look critically at all the regulatory programs when you're doing construction permitting. But it is the same 45-day review period by EPA and the 30-day public notice. If you add a new piece of equipment that would require a significant mod, you do have a couple of options for processing that. You can just apply for the construction permit and then incorporate it into the Title V later within the 12 months of beginning operation, or you can use a consolidated permitting option where you're working through the construction permit and the Title V significant modification together in one action. Permit renewal applications, so those sources that have had their Title V permit, every 5 years the permit expires and you need to get the renewal application at least 12 months before the expiration, but no earlier than 18 months before expiration. So generally you're asked to provide an information of all that information we went through on the initial application. So it's, think of the same forms, although not necessarily every form depending on the scope of the changes. And as far as the actual work process goes in practice on renewal applications, you're looking at things like maybe equipment that's not yet in your permit, rule changes or new applicable requirements that don't show up in your permit. And a lot of times a red line is a very efficient method of communicating between the source and the agency. There is also a need to evaluate CAM applicability for new sources installed during the permit term, and CAM stands for Compliance Assurance Monitoring. And at a really high level, it's an additional monitoring requirement put in by EPA, really intended for the oldest units that may have been grandfathered from NSR permitting or are only subject to some of the older NSPSs. And there's three main criteria. Is there some emission limit or standard that unit has to comply with? Is there a control device that you're using for compliance for that pollutant? And are your pre-controlled emissions more than the major source thresholds? So it does take a bit of effort to work through that. There are a lot of exemptions already built in the rule that, for example, if you're subject to more recent NSPS or NESHAPs, or if you already have a SEMS or some method of continuous compliance demonstration, you don't have to go through CAM because you're essentially already meeting the goals of what CAM would do. But there are some other exemptions as well. There's quite a list that you can look at when you're working through your sources. And this slide is mostly for the presentation PDFs, just to help summarize the application timing requirements. We've talked about some of those, especially the 1-year timing that applies pretty commonly and is most of interest here with the redesignation. There is a duty, to supplement within 30 days of receiving a construction permit if you haven't received a Title V permit. So I think that's second from the bottom. That may come up a little bit for some of these new sources that are going into Title V. And with that, I'm going to turn it back over to Dawn.
Great, thanks, Tony. I want to make sure, can you hear me okay?
Sounds great.
Fantastic. So next, we're going to spend some time discussing deviations, reporting, and compliance certifications. The fun part. So under the Title V program, there are 3 key types of reports that need to be filed, and we will walk through each in more detail. The first is the prompt reporting of certain deviations. The second is the semi-annual monitoring report, and then finally, we're going to go over the annual compliance certification. One aspect of all the reports is the term deviation. A deviation means any situation in which an emission unit fails to meet a permit term or condition. A deviation isn't always a violation. Violations are determined by the regulatory agency. So in other words, it's at their discretion to determine if a deviation is in fact a violation. And associated to that, not all deviations or violations will result in enforcement or fines. EPA spells out a number of example deviations, such as when emissions exceed a limit or a standard, parameters are outside of a required range for control equipment or a process, observations or data demonstrate noncompliance, if there's an exceedance of throughput and fuel limits, or if monitoring is not conducted. And then finally, if there's a failure to submit a timely report. That's also a deviation. So this is an example of the CDPHE's Title V deviation reporting form. This is part 2 of the semi-annual monitoring and deviation report. So what you have to answer here is the deviation an emergency or is it a malfunction? Did it occur during normal operations, startup shutdown, or malfunction? What is the corresponding permit condition? You will need to document the dates and times of the deviation. When you have a deviation, you want to put forth a detailed description of its probable cause, your corrective action, and preventative measures moving forward. To the extent one is needed, a root cause analysis is excellent communication. You want to demonstrate how the incident wasn't reasonable or foreseeable and not a recurring problem. Finally, you want to show some action in order to prevent recurrence. Let's say you just missed a visible emissions reading. You check with the staff who usually does this, and it turns out that they were home sick for the day. Based on that information, the root cause was that only one person was trained to do this, and that there wasn't any sort of notification that the primary person wasn't available to complete this monitoring. You might train a backup, work with their supervisor for notification, or something along those lines to demonstrate improvement in your program. So each state has their own requirements. Colorado rules generally define prompt as submission of reports of deviations from permit requirements at least every 6 months, except as otherwise specified by the division in the permit. Or there are a couple specific situations where you have to do a more prompt report. If the emissions of a HAP continue for more than an hour in excess of permit requirements, then a report's required within 24 hours, and generally that's a verbal notification. If any other regulated air pollutant besides a HAP is emitted for more than 2 hours in excess of permit requirements, then another verbal report is required within 48 hours. So in addition to deviations, there are also excess emission reporting requirements, which should be reported as soon as possible, but no later than 2 hours after the start of the next working day for excess emissions during startup and shutdown, and then by noon of the next working day for excess emissions as a result of malfunctions. A written follow-up is also required. So to tie it all together, you'll want to consider building a flow chart for your site to lay out relevant scenarios, the reporting requirements, and any corrective actions and methods to reduce excess emissions that you come up with in advance of these events. For example, does everyone at your facility know what to do if a certain scrubber pump fails? What happens if there's a power failure? The prompt reporting requirements make it a necessity to have a plan in place. Beyond the prompt and excess emissions reporting requirements are the semi-annual reports, which encompass all deviations during the 6-month period. This should include deviations identified by your continuous or periodic monitors. It includes declaration of monitor downtime and any other deviations you discover through record keeping. We walked through the examples of deviations earlier, but a few other specific things I've seen are missed visible emission readings, pressure drop out of range for a few hours, and then also engines operating without permitted controls, just to name a few. So this is the template used for the semi-annual monitoring and deviation reports, and it's typically found in Appendix B of your Title V operating permit in Colorado. An example of Part 1 of this report, which identifies each emission unit covered by the permit, is here on the left. You will document deviations during the period, the deviation code, and whether there was a malfunction or emergency condition during the reporting period. The deviation codes specify whether that deviation was due to a standard, process, monitoring, testing, maintenance, record keeping, reporting, CAM, or there's also a quote other deviation that may not be specified. Part 2, which we showed earlier, goes into detail about any of those reported deviations. And then Part 3 on the right is the certification by the responsible official. Note that the semi-annual reports are only required to be submitted to the state division, the Air Pollution Control Division, and not the EPA. The annual compliance certification summarizes the 2 semi-annual monitoring and deviation reports. In Section 1 of the annual certification, you're required to identify each of your emission units, any deviations, whether the monitoring method was completed per the permit requirements, and report whether compliance was continuous or intermittent. Intermittent compliance does not necessarily equate to non-compliance. If the operator does not have sufficient data to certify continuous compliance, the intermittent box is checked. Periodic monitoring requirements are intended to provide assurance that in the absence of a continuous monitoring system, a source can still demonstrate compliance by conducting monitoring and record keeping as required in the permit, even if it is periodic and not continuous. In Section 2 of the annual certification, you are reporting on the facility status of the Accidental Release Prevention Program, which is Section 112R of the Clean Air Act, and whether or not an associated risk management plan will be or was submitted. The annual compliance certification is then signed by the responsible official, and it must be sent to both the Air Pollution Control Division of the CDPHE and EPA Region 8. This is typically found in Appendix C of your Title V operating permit. So the certification statement is where the involvement of the responsible official comes in, which is not the environmental engineer tasked with the environmental compliance program. That responsible official, which generally is someone at the vice president level of the organization, has to certify truth and accuracy. The RO, responsible official, does not have to have absolute knowledge and can rely on staff like the environmental engineer and the operations staff to provide the relevant information. But it's important to note here that the RO could be held accountable for prosecution if they know what they are certifying was not true, accurate, or complete. I'm going to turn it back over to Tony for some specific examples and to talk about compliance programs.
Forgot to unmute. Thanks, Don. Yeah, so let's do some examples, help break it up a little bit. So this first example, just generally an unofficial observation. So we have a bag house with a 20% opacity limit and a once daily observation requirements. You completed your daily observation and there were no problems. But then you're out for lunch, you're coming back, you see a plume on the horizon, and drum roll. Don and I we'll see if we can get our timing right. She's got to click one more for the animation. There we go. Yes, you do have other material information that requires additional action. So you would have to go do a follow-up method 9 observation to verify what the opacity was. Okay, next one. Another example is you have say a continuous pressure drop monitor and you have that hooked up to your data acquisition system, your permit only requires one daily observation. So you have a more robust system than what's necessarily required. And every day your operator notes at the start of the shift where that pressure drop is, and it'll look great. But then later on, you go look at the full data and you see it wasn't compliant all day long. So in that case, you have to report a deviation because you do have data showing non-compliance. That's material information. You can't just ignore that because it wasn't the time you chose to view it, that you are in non-compliance in that case and need to initiate corrective action. Another example, so you're required to do just a monthly visible emission observation from bin vent or some other type of source, and normally you do that on the first day of the month. You just happen to be out sick, and then the equipment goes offline for the rest of the month. So it operated that first day. There was no observation then. So in that case, you do have a deviation for failure to monitor in that case, because it was operational and there was no monitoring completed. If you do have a deviation, I mean, what all that means is you have potential risk for enforcement, and Colorado penalties can vary, as you'd expect, based on the type, the duration, the severity of the violation, and in some cases, your company's compliance history as well. Actually, probably in most cases, that plays a role in the enforcement action. In addition to just the state penalties, EPA can also enforce and impose fines, either with or without the CDPHE. EPA civil penalty is around $100,000 per day per violation, or its maximum, I should say. I think in practice, normally that gets negotiated down, but that is the hammer that they can come in with, which is pretty severe. That is higher than other programs like RCRA, which is around $75,000 per day, and Clean Water Act is about $56,000 per violation per day. And Dawn's noted this in her slides too, but don't forget the cover-up's always worse than the crime, and you don't want to go into the realm of criminal penalties. So I'm going to talk a little bit about compliance programs, which at a high level, we're thinking about, if you have a permit, you need to build a program around it. And there's more than probably a little philosophy that goes into a Title V compliance program. Some organizations implement robust, ISO programs and dedicate significant resources to make sure no stone is left unturned when it comes to their Title V compliance. Some other companies or facilities are probably a little more like how Homer would approach a Title V program. So it's a legitimate question to ask when you're working on this. How do you want to manage your Title V compliance system, considering the resources available to you, your organizational views on environmental compliance, what makes the most sense for you? Because those are two pretty extreme ends of the range, and most everybody falls somewhere in the middle there. But that's a lot of potential options of how to approach it. Because at the end of the day, with the annual and semi-annual reporting requirements, for all your permit conditions, you need to be able to say your compliance status, whether it was continuous, intermittent, any deviations, excursions, exceedances, and this is a single emission unit table. Your table is going to be much longer than this excerpt as you go through all your conditions. Again, working backwards from that end game, you have to do those reports. There's a clear step where you need to fill out a table like that for all your individual requirements in the Title V permit. And in practice, you probably need to break those down even further to compliance tasks, especially when those requirements are broad. Like if you had a requirement that just says to comply with an NSPS or MAX subpart, there can be many elements to that. And when it comes to the presentation to the agency, you can always roll that up within your tools to match what CDPHE is looking for. But it's not, that is, a rolled up tool is not necessarily practically useful for you and your compliance tasks. So setting up clear tasks is one of the most important steps in the process. So we're picking on visible emissions today, mostly just because it's pretty easy to understand and pretty ubiquitous too. This is a pretty generic condition. We're going to pick a couple compliance tasks from it. You know, a conditional task here in this first, within this first box is to perform a method 9 observation each time the engine startup period exceeds 10 minutes. And further up in the paragraph, you can see the limit is 30%. And secondly, a visual observation shall be performed quarterly during normal operations. So it's another task that you need to follow up on. Probably noted there's no record keeping or reporting in that excerpt. This is a record keeping requirement that's more general within the Title V permit, and there's something similar for reporting as well. So if we carry this forward, you know, what are your actual tasks that you'd be doing? And in this case, we said the operator is going to share the burden of doing those visible emission observations, since they're the ones that are running the engine or are going to be there. But there could be a lot of considerations that go into that, and make sure there's clear direction on what and when those things need to happen, and there's motivation for that operator to comply with those requirements. And so you're working as a team, you know, environmental and the operator, to comply with those conditions. And you know, the devil can be in the details on these, where you really need to have everything lined out to ensure you're in compliance, you know, with even these, you know, simple permit conditions like an opacity limit. You also have to be prepared for the inevitable when you aren't in compliance, and know what to do to lower your risk. You know, at a high level, we won't go through every single one of these questions, but you need to find out what happened, build a defensible position that you're doing everything you can to mitigate environmental harm and prevent a recurrence of the deviation. So then when you roll it up and it comes time for certification, you know, CDPHE is going to care about, you know, clear permit compliance. You know, did you exceed the limit? Did you do your visible emission checks and document them and report them? But you know, as we just walked through, I mean, there's a lot that goes into being able to answer those questions, you know, yes or no, and have the supporting documents. So if we keep working back further, I mean, visible emission is a pretty manual thing, but there's a lot of electronic records that can and should be used on the raw data collection side. And compared to when the Title V program first came into effect in the 90s, it's a much more attainable goal to keep most, if not all, of your records electronically. Obviously, a lot of advantages, but the more you can automate, the less staff time it's going to take to manage the compliance with your permit. And you can see the data real time. You can set up automatic verification protocols and alarms. You can build a pretty robust system. But it's probably not going to be possible for every single record you need, say something like a visible emission monitoring. And there may be limited feedback to automating something like that, you know, even if especially if it happens only once or twice a year. So building up from the raw data, you want to have your tools that link, ultimately, connect the dots between your data and your permit requirements. And how you do this is going to be your most easily auditable record, and is what you're likely going to rely on primarily for your compliance reports, both on your end and what the agency would review. So a strong environmental management information system can be an important tool for implementing compliance tracking. So the tools used are vary quite a bit from site to site, company to company, and depend on a number of factors. Part of this, getting back to the philosophy discussion earlier, the best choice for your facility is going to depend, how much time you have to prepare for Title V, what systems are already in place. You might have a third-party management system that facilitates environmental tasks, procedures, and record keeping, and you can work with that. I think, facilities are pretty commonly reliant on Microsoft Office products to, especially Excel, for data processing and tracking. And, Microsoft's made pretty significant upgrades to their Office products recently that could help, they have some potential to help improve the management of tasks as well. But no matter what tool you use, you're still going to need to spend time up front developing the relevant tasks and procedures and populating that tool. So with that, I am going to turn it back over to Dawn to wrap up.
Okay, thanks, Tony, and hello again, everyone. Let's see here. So now we are going to wrap up and then give you all some time for questions. So what's next? If you are a newly designated major source in the Denver Metro North Front Range, boy, that's a mouthful, ozone non-attainment area, what do? Do you become a synthetic minor source? Are limits reasonable to keep you below those major source thresholds? Or do the limited operating rates outweigh the compliance costs we spoke about earlier today associated with Title V? Or do you just go ahead and embrace Title V, submit your application, put systems in place to verify compliance, record keeping, and reporting? What are the resources companies need to comply with Title V permits? As both Tony and I have mentioned, the key to complying with Title V is to have a well-planned and documented compliance program. Your compliance program breaks down your Title V permit into individual requirements. You will then develop compliance tasks and owners for each of these requirements. The compliance tasks will identify monitoring, record keeping, and reporting methods and responsibilities. And as we mentioned earlier, a compliance program can be a very sophisticated EMIS, Environmental Information Management System, or as simple as using calendar reminders and spreadsheets. It all just depends on the complexity of your facility and the requirements in your Title V operating permit. So as you're working through your own Title V permitting process and permits, here are some helpful references. The CDPHE's website, they've got guidance documents, the forms, the flow charts, and then EPA has several very useful resources as well. Their Title V operating permit policy and guidance document, the Title V petition database, CAM guidance, and then applicability determinations as well. So I just want to say thank you so much for participating in our webinar today. And now we can take any final Q&As. Lori, I'm thinking maybe since you're our host, if you could see if, I don't know whether people want to unmute or just use the chat function and let us know what questions they might have.
Yeah, I'm looking at the chat and I'm not seeing anything come up. If anybody wants to chime in, you can either raise your hand or just turn off You're mute.
I have to say this was challenging doing this all virtually. COVID has definitely presented some unique challenges, and we're getting better at virtual presentations and communications. We'll just give it another minute here.
Yeah, it looks like we've got one hand up from John.
Okay.
You want to go ahead and unmute and ask?
There we go. Can you hear me now?
Yep.
Hey, just a quick question on timing. You had, toward the end of your presentation, you discussed establishing a synthetic miner, for example, as opposed to going through the application process. For timing purposes, does that, in Colorado in particular, does that permit have to be issued by the January deadline? Or
Yes.
a Title V application that has to be issued by that date?
The synthetic miner construction permit has to be issued by January of 2021, or if it's not issued, you have to submit a Title V application. If you get in a sticky situation where your construction permit isn't issued to enforce those synthetic miner federally enforceable requirements, it might still be pending, but you would have to go ahead and submit the Title V application in order to retain permit shield and not risk enforcement.
Excellent. Thank you.
You're welcome.
We have one chat question from Doug Huxley. It says, is intermittent compliance the same thing as we had some deviations during the reporting period?
Yeah, I would say so. Yep, because you're in compliance, not the entire. It's not continuous. It would be intermittent. Hopefully, you're in compliance at least some point during the period.
And, you know, as I mentioned earlier, too, with intermittent compliance, you're not necessarily out of compliance. You just may not have a continuous system or program in place to verify continuous compliance. So intermittent doesn't necessarily mean a deviation or out of compliance. Okay, we've got about 5 more minutes left, and I do believe we will be uploading these slides to the AWMA website. And, you know, please feel free to reach out if you've got any questions. Tony and I's contact information, both our phone numbers and our email addresses, are listed here on the last slide. And just want to say thank you all for your attendance today.
Yeah, and one other thing to note is we did record this as well. So if anybody wants to go back and look at the video of it, it will be available on the, I think there will be a link on the Rocky Mountain section website. So thank you everybody for attending. Appreciate the support.
Yeah, thanks everybody.
Thank you. Have a good afternoon.
Thanks.